Write a short note on the difference between amalgamation and dissolution. It is important to distinguish between amalgamation and dissolution, especially when a scheme of amalgamation is proposed involving a company that is undergoing liquidation. Although both concepts affect the existence of a company, their nature and legal consequences are entirely different. Amalgamation refers to the combination of two or more companies into single company. The provision relating to amalgamation are contained in section 232 of the Companies Act 2013. Amalgamation may take place by the merger of two or more companies into one company or by the acquisition of one company by another. As a result of amalgamation, the separate identity of the amalgamating companies ceases and a single company continues the business. However, amalgamation does not completely wipe out the existence of the amalgamating companies. Their assets, liabilities, rights, obligations, and business interests continue in the amalgamated company. Thus, the business survives in a new or continuing corporate form. Dissolution is the final stage of winding up of a company. It brings the legal existence of the company to an end after collection of assets, payments of debts and liabilities, distribution of surplus assets among contributories or shareholders. The company is dissolved according to the provision of the Companies Act 2013. Once dissolved, the company ceases to exist as a legal entity and cannot carry on any business or hold any property. Let's look some differences between amalgamation and dissolution. The meaning of amalgamation is to combination of two or more companies into one company, while dissolution means complete termination of the company's legal existence. The governing provision of amalgamation is section 232 of the Companies Act 2013, while for dissolution, provision relating to winding up and dissolution under the Companies Act 2013. So both are in Companies Act 2013. The continuity of business in amalgamation is to business continues in the amalgamated companies, while in dissolution business comes to an end. For the assets and liabilities, the amalgamation transferred to the amalgamated company, and for dissolution it is realized and distributed before dissolution. The legal existence in amalgamation continues in a merger or reconstructed form, while in dissolution it completely extinguished. The objective of amalgamation is to corporate restructuring and business growth, while for dissolution, final closure of the company. The effect on company in amalgamation is to company merges into another company, while in dissolution, company ceases to exist permanently. Importance of distinction. The distinction is important because amalgamation aims at business continuity and corporate restructuring. Dissolution aims at ending the existence of the company. In amalgamation, rights and liabilities continue. In dissolution, all affairs are finally settled before the company disappeared from legal existence. Conclusion. Thus, amalgamation and dissolution are fundamentally different concepts. Amalgamation under Section 232 of the Companies Act 2013 results in the continuation of business through a new existing company, whereas dissolution results in the complete termination of the company's existence after widening up. Therefore, the effect of dissolution is exactly opposite to that of amalgamation.